For family law practitioners, adult relationship breakdown presents a specific operational challenge, navigating the precise legal mechanisms required to terminate or suspend the marital obligation. This process is governed by two foundational statutes. Marriages fall under the Matrimonial Causes Act, 1973, while civil partnerships are regulated by the Civil Partnership Act, 2004. The Divorce, Dissolution, and Separation Act 2020 replaced previous laws with a streamlined set of procedures. Applicants no longer have to prove fault using 5 specific facts, like adultery. It is replaced by a simple statement that the marriage has irretrievably broken down. By removing the need to prove fault, the legislation effectively eliminated the concept of the defended divorce. It is currently impossible to contest a dissolution simply because one party disagrees with the separation. In fact, there are now only 3 exceptionally narrow grounds to dispute an application: a lack of jurisdiction, an invalid marriage, or a marriage that has already legally ended. Relationship dissolution now functions as an exercise in navigating strict statutory waiting periods, removing the previous evidentiary battles over blame. This diagram maps the timeline of those waiting periods. The clock starts at day 0, the ceremony. Immediately, we hit an absolute statutory barrier. Under Section 3 of the Matrimonial Causes Act and Section 41 of the Civil Partnership Act, a practitioner cannot file for divorce or dissolution within the first year. You can, however, rely on events that occurred during this first year as evidence once that 12-month period officially expires. Once the 1-year anniversary passes, the application phase begins. The process is now heavily digitized. Family lawyers are required to use the professional HMTSTS online portal to manage and submit these applications. To file successfully, you need specific documents: the matrimonial order application, the marriage certificate, the court fee, and a statement confirming reconciliation has been discussed. Under the updated laws, there is also a structural change to how the application is filed. It can be submitted by a sole applicant or jointly by both parties. If a joint application is initiated but one party fails to acknowledge or complete their section, the law provides a switch mechanism, allowing the responsive party to convert it into a sole application and proceed. But successfully issuing the application is just the starting line. It triggers a series of mandatory, non-negotiable waiting periods. Looking back at our timeline, the first major statutory hurdle is the 20-week cooling-off period. The practitioner cannot apply for the next stage of the divorce until exactly 20 weeks have elapsed from the date the initial application was issued. This next stage involves applying for what is now called the conditional order, the legal milestone previously known as the decree nisi. Once the conditional order is pronounced, a second statutory clock starts. You must wait a minimum of 6 weeks before you can apply for the final order. The final order, which replaces the decree absolute, is the legal instrument that actually terminates the marital status. Together, these waiting periods create a locked 26-week minimum duration from issue to completion. It acts as a structural safeguard to ensure reflection, regardless of how quickly the parties want to finalize the split. For clients who require immediate legal separation but are blocked by the 1-year statutory bar, there is an alternative route. The solution is judicial separation, governed by Section 17 of the Matrimonial Causes Act. This mechanism bypasses the 1-year waiting rule entirely. Like divorce, it requires a statement that the relationship has broken down without proving fault. However, it does not formally dissolve the legal marriage. This route is strategically useful for 2 specific client profiles: those whose relationship breaks down in the first 12 months and those who have religious or cultural objections to formal divorce. Judicial separation provides an immediate pathway for the parties to live apart, complete with court-ordered financial protections, without ending the legal marital status. This matrix evaluates the precise legal outcomes of divorce versus judicial separation. Both legal pathways immediately end the formal duty to cohabit, establishing a legally recognized separation. They also both trigger the court's ability to issue financial and property orders. But there is a major financial caveat. Pension sharing orders are strictly excluded in judicial separation. In terms of inheritance, both mechanisms carry the same consequence. Spouses lose the automatic right to succeed to property on the intestacy of the other. The absolute defining distinction, however, is finality. Because judicial separation leaves the marriage intact, neither party is legally permitted to remarry or enter a new civil partnership. The choice between these two pathways is a strategic trade-off. The client must weigh the need for immediate relief against the long-term finality of a clean break. This leaves the practitioner with a clear procedural decision tree: the 12-month statutory bar, the 26-week divorce timeline, and the Section 17 judicial separation bypass. The divorce pathway requires filing the statement of irretrievable breakdown and strictly managing the mandatory cooling-off periods for the conditional and final orders. The judicial separation pathway offers a bypass for immediate action or religious accommodation, but it sacrifices pension sharing and the right to remarry. Mastering these two structural frameworks and their procedural timelines has replaced the historical focus on litigating fault or assigning blame. By understanding the rigid statutory timelines and their long-term legal effects, practitioners can ensure their clients receive a precise, strategic exit from the marital obligation.